We spent $35,000 to correct his errors. 3 years. 3 years now.
And a big part of that delay was their fault.
We're
not going there.
No.
That's not this case. That's not this case. It's about $2,500 on a license, and I have the information that I need.
Thank
you all.
I'd just like to clear one thing up from the plaintiffs. Are you suing him in another forum for other things?
Yes.
Just a yes or no? Okay.
Breach of contract.
Thank you. All right. We're going to excuse the parties while we deliberate in this matter. Thank you all.
Thank you.
This courtroom is now in recess.
Okay, then. So I think we all came at this from a different angle. So I think I'd like to kind of settle up certain issues. First of all, he can, as an unlicensed individual, work appropriately in any jurisdiction that requires a license if he works for a company that is licensed and insured. So throughout the beginning of this work, he was appropriately working. At some point, he stepped away from the company, and he then was going to be helpful to them, and he now works on his own. In order to do that, he needs a license, and so he thinks it's going to cost $2,500. I don't think in its inception he was willing to deceive them, to take it, to threaten, to anything at all. So now he can't get this license. He can't get it. It's not enough money for him to get the insurance and all that. So I'm going to believe him that he put the money back into the business. I never saw any evidence that he didn't put it back into the project. So now, to me, he's an unlicensed contractor. Technically, though we like it or not, they can sue him for all that money back where he worked unlicensed, which would include this $2,500. However, that would require us to change from the fraud allegation to basically, I'm suing you because you were an unlicensed contractor, and the law says I can. But that might be precluded by the fact that they already have a cause of action going for that.
I disagree with your theories of liability, but I do think that Judge Acker clearly illustrated how this relationship morphed into something different. I don't think that he had the intent of operating without a license or is liable because he wasn't licensed. I don't go there. But I do think that he used the money for a different purpose, and especially since he sent an email indicating, send me the money, and then he realized, well, if I give this money to my sister, it's just going to be taken up for other purposes. But I do think he's liable for the $2,500 on that basis. He just used it for the wrong purposes. And under those circumstances, I think they're entitled to that $2,500.
I agree with you. No fraud. There's no evidence that he intended to deceive them. No. It's not fraud. They're clearly angry about the way this project unfolded generally, but that's not before us. And if there's another proceeding subsequent to this, then our ruling is going to be res judicata on the issue of recovery for that $2,500. So I joined Michael with the $2,500.
Wait, because you think that in the other lawsuit they would be...
I know nothing about the other lawsuit. If we rule that he's liable for this $2,500 on the theory that he paid for a license, they can't get another recovery for $2,500 on the theory that they paid for
and not only that,
No, but they wouldn't have been doing that there. I think they would have been doing it as part and parcel of his breach of contract for not doing the work properly, and they paid him.
We should make it clear to them. They're suing essentially on the basis of a check made out to the defendant. And I think it's severable from the breach of contract.
That you think goes for the whole business. The defendant then can use this $2,500 verdict in his favor in case this is included in the other lawsuit. With that in mind, I will then be on board giving them the money, even though it wasn't under fraud. Well, gentlemen, I want to say that we had a very interesting deliberation, and we had to look at this case from a different perspective than we usually do other contractor cases. We are unanimous in finding that you are entitled to recover your $2,500, but not because of fraud, but because, sir, you actually took the money from them with a promise that you were going to use it for a particular purpose, and you did not use it for that purpose. You kind of breached that agreement that you had with them. Another thing that went into our deliberation here, so that you both know this, is that you have a pending lawsuit, according to your testimony here, suing the defendant and or the company that he was working with regarding the work done with your room extension. And so because of that, sir, when we render the verdict in their favor, you will have a copy of that judgment. So if for any reason they include this particular $2,500 in any other lawsuit, you say, here you go, court, they've received a recovery in this matter in a small claims court, hot bench, they are not entitled to get that money again. Do you understand that, sir?
I do.
So with all that in mind, the verdict is in your favor for $2,500.